Good afternoon. Let's get started with our Tuesday, February 9th meeting. We have no request for bill introductions today, thank goodness. We do have two bill hearings though, and so we will just get started. The first one is House Bill 2227. We'll open the hearing on that and have Natalie give us some information about it.
Thank you, Mr. Chairman. House Bill 2227 allows the Chief Justice of the Supreme Court to suspend certain time limitations during a state of local disaster emergency, suspend verification requirements, and permit the use of electronic audio-visual communication to resolve cases. It also extends the authority to suspend the time limitations until June 1st of 2022. So the bill amends KSA 2172. Current law there allows the Chief Justice of the Supreme Court to suspend time limitations during a state of disaster emergency declared pursuant to KSA 48924. This bill would give the chief that same authority during a state of local disaster emergency. It would also allow the chief to suspend the verification of an appeal required pursuant to KSA 382273 during those types of disaster emergencies. Further down in the section, current law allows the chief to issue an order to authorize the use of two-way electronic audio-visual communication in any court proceeding when the chief determines that that action is necessary to secure the health and safety of court users, staff, and judicial officers. This bill would give the chief that same authority when the chief determines it's necessary to expeditiously resolve pending cases. And then finally, the current law provides that this section will expire on March 31st, 2021. That was part of Senate Bill 14 that you guys passed earlier this year. This bill would provide that subsections A and C would continue to expire, but they would not expire until June 30th of 2022. And I can take any questions.
Thank you, Natalie. Representative Carmichael.
Thank you, Mr. Chairman. As I recall, last year when the Chief Justice came to us requesting legislation related to the pandemic, the court also included extensions of statutory speedy trial. Now, maybe I don't recall that correctly, but in looking at this bill, it appears that statutory speedy trial is not discussed as one of the things that could be suspended by the Chief Justice under this legislation. Do I understand that correctly?
Mr. Chairman, this is the section that allows the chief to suspend any time limitation established by a statute. So this is the section that allows her to issue that order to suspend that speedy trial or civil statutes of limitations and things of that nature.
So then this does, in fact, afford the Chief Justice the same authority that she has previously exercised as it relates to speedy trial?
Yes, when we originally passed that legislation, we put a statutory cross-reference to this section in the speedy trial statute, so people would be aware that possibility that the chief could extend that pursuant to this statute. But when she does that, she's doing so by issuing an order pursuant to this statute. So that's where the statutory changes would be.
And my recollection was that, previously we made provisions for speedy trial delays to go, I think, 150 days or perhaps more following the end of a state of disaster. How does this legislation deal with a backlog of cases if the chief should decide to suspend speedy trial rights?
Mr. Chairman, this legislation would not change that 150-day limitation after the state of disaster emergency were to expire.
Thank you very much. Your answers are very helpful. Thank you, Mr. Chair.
Representative Owens.
Thank you, Mr. Chairman. Natalie, I wanted to clarify, just based on the dates here, that this would expire June 30th. So is it still tied to, is her authority still tied to an active declaration of emergency? Or does this negate there needing to be an active emergency and she just has that authority through June 30th?
Mr. Chairman, sorry, I went away from my, you'll see in subsection A, we still are requiring, the only time she can make these extensions or delays of the time limitations is during a state of disaster emergency declared pursuant to KSA 48924. So we would have to be under that disaster declaration. This bill would also, though, add any state of local disaster emergency that was established in KSA 48932. So we'd have to be under one of those types of disasters.
Okay, thank you for clarifying. Thank you, Mr. Chairman.
Representative Jennings.
Natalie, can you tell us what the character of emergencies are contained in 48932?
Mr. Chairman, the that statute provides that a state of local disaster emergency may be declared by the chair of the Board of County Commissioners or a mayor of a city upon a finding of such officer that a disaster has occurred or the threat thereof is imminent within such county or city.
And the use of the, I guess the operative word there is disaster, so it would be any type of disaster for which a declaration might be made, whether it be health or flood or fire or whatever.
Yeah, it could be. And so this would be a declaration by a local unit of government as opposed to the governor.
Any other questions for Natalie? Do not see any. We will begin with proponents, and the first one online is Sean Jurgensen from the Judicial Branch. Good afternoon, Sean.
Good afternoon, Chairman Patton and members of the committee. Thank you for allowing me to appear today and visit with you about HB 2227. I don't really have much to add to what Natalie described where we're at today under KSA 2172 or what the bill would do. All I would ask is that as we consider the Chief Justice's emergency powers, that we include the flexibility necessary for the judicial branch to respond to emergencies, no matter how those emergencies may manifest, so that we can do that to the fullest extent possible to continue our operations here at the court system. And I think that today, emergencies present differently than they have in the past, whether it's a cyber threat, or I know that recently we suffered a courthouse basement fire out in Johnson, or even a pandemic that can present in various new variants as we move forward. And so permitting us that flexibility to respond to the fullest extent possible is where we came from in crafting this as you consider the emergency powers. And we believe that these amendments would add to that.
Very good, Sean. I've got one question for you right out of the gate. So we were fortunate to be here last year when COVID began to hit and things were shutting down. And so the chief could come over, and we passed, I think, Senate Bill 102 at the time that gave the chief these powers. But my concern is what if it happens in October and the legislature's not here? What would we have done? And so I like the fact that we're not allowing these provisions to go away on March 31st, because we're certainly going to have issues with the court that she needs the power to continue to delay things. But why the new June 30, 2022 sunset? Why should this provision not be in place whenever there's a disaster? So if we're not here in October 2023 and something happens and the chief needs to suspend some deadlines, she could.
Right. And at the no objection to striking the sunset at the interim KEMA committee, we testified that would include the fullest extent of our ability to respond would be striking that sunset provision. Because, yeah, like you said, in that situation, we could find ourselves in a needing this language. I think that what we included that language there because we wanted to present it to this new committee. There are members on this committee that weren't present at the interim KEMA committee last fall for consideration and discussion, but certainly that was our starting point last fall and does provide us the fullest degree of flexibility. And so I think that would be a sound policy choice.
Thank you. Representative Samsel? Are you out there, Representative Sampson? Your hand's up. Hands down. Anyone else have questions? Okay, we will move on to Joe Molina.
Thank you.
Thank you.
So it has to be on. Joe Molina with the Kansas Bar Association. I appreciate the time, Chairman Patton. We support House Bill 2227. It gives the court all the flexibility they need. We've shown that they've used that flexibility wisely. They've created innovative programs. During the pandemic, even with limited resources, they created domestic violence programs. They created a marriage license portal, a pay portal, and all of these types of things was basically brought forth because of Senate Bill 102. I think the biggest thing that they probably was able to do was do audio-visual hearings. I believe the Supreme Court has done mostly all audio-visual hearings for the last 10 months. That is extremely important to my members because if they have a case, you can read the case. But if you want to learn a little bit more, you can get on YouTube and you can watch the hearing. That is something that's vital when you're trying to interpret what the court actually meant on certain things. And so I think that's a big piece of why we support the bill. We believe that they need these types of flexibilities going forward. I know we're in the midst of a pandemic, a 100-year pandemic, but Kansas is known for other things. I have to remind my mom all the time that tornadoes don't always happen in spring in this great state. And so that's why this type of flexibility is needed, and the KBA supports it. If I have any questions, happy to stand.
Any questions, committee? Do not see any. Thank you, sir. Committee, you have written proponent testimony from Amanda Stanley. Is there anyone else here as a proponent? Okay, we have neutral written testimony from the Kansas Association of Criminal Defense Lawyers. Anyone else here neutral? What about opponents? Anyone here as an opponent? Don't see any of those either, but I do see that Mark Samsel's back. So Representative Samsel, did you have a question you wanted to ask anybody?
Yeah, sorry about that, guys. Having technology issues. Can you hear me okay now?
Yes.
Awesome, thank you. My question is from some of our colleagues in the bar, particularly related to landlord-tenant issues. But does this get into, it sounds like we have some issues down on the weeds on whether these suspension of deadlines apply to like things in the normal mill of cases, like summary judgment briefing, if you will. There's issues as to whether this tolls a 21-day response line, the deadline for motions or other pending motions. And I don't know if this bill is the proper place for it, but I do have heartburn even from my own practice of not giving the Chief Justice authority, but depending on how the language of the orders and stuff comes down, I know there's some fairly serious heartburn, and it's to the point where it's affecting a lot of our landlords, among others, in not being able to effectively move cases through.
Is there a question mark at the end of that for anybody or just a statement?
Well, it could be for either of the proponents, okay, I guess, but is that something that we can flesh through, work through? Does that need to be as part of legislation? I guess I have heartburn in extending the Chief Justice's authority carte blanche out further unless we're able to address those issues, which I'm sure we can work through those. And I don't know that this is the proper place for it, but I at least wanted to raise the issue and concern because I've talked with several attorneys where that's 95% of their practice is representing landlords. And in some cases with the COVID stuff and pandemic, I mean, it makes sense, but in other places there's tenants taking advantage of this stuff. And I know it's my issues that I've raised are not the only ones. Like it's a fairly common issue in the bar right now where it's perhaps gray areas that we could flesh out better, whether it's coming from a Chief Justice, one of her orders, or from legislation or whatever needs to be done. Just as an example, making it clear, at least I think the better policy is, if you've got a case that's pending, these Chief Justice's orders are not intended to suspend the normal motion practice of a 14-day deadline or a 21-day deadline to respond to summary judgment, things like that.
Sean, do you want to reply now or should we?
Yeah, I can reply.
Okay.
So the Chief Justice's authority is to suspend statutory deadlines and time limits, and there is an administrative order on file that allows case-specific orders to be entered by judges at the district court level. And so a district court judge in a case should, whether it's regardless of which case it is, that they can exempt that particular case from any suspension of timelines or deadlines, so that the cases are moving forward, and that is occurring. So hopefully that helps reduce Representative Sampson's heartburn.
Thank you, Sean. It actually does not, though, because I think the burden's flipped on its head right now. It seems like, yes, we have a pandemic still, but I don't think this is an emergency where we're taken aback by anything now. It seems like a lot of these normal case deadlines should be the norm. And then if a judge, local judge, district judge wants the discretion to pause those, that's fine. But I use as an example, I have a case where everything has been paused, if you will, and we're trying to get a Chapter 61 judge and a Chapter 60 judge to put the normal deadlines back in place. And because of the number of cases on their docket, perhaps, I don't know, but to me, the better public policy right now is the normal run of cases ought to be normal. And then if the circumstances warrant, allow a judge to put in an order, perhaps upon motion of a party, to pause, like whether it's 60-256 for summary judgment, or let's say you've got a brand new case and you've got a 60-212 motion. I would have no objection if there's a motion brought to pause the normal run of those cases, but I don't think that ought to be the norm right now in light of but that's, again, I'm getting a little bit more of a preaching, I guess, or my position there, but I guess that's something that I would want to work out as we move forward, though.
Any other questions? Okay, we've been through proponents, neutral, and opponents, so I will close this hearing. We'll move on to House Bill 2229, open that hearing, and go back to Natalie for an overview of the bill, please.
Thanks, Mr. Chairman. House Bill 2229 increases the criminal penalty for multiple thefts of mail. So the bill amends the theft statute, which is KSA 215801, to provide that property that is mail of a value of less than $1,500 from 3 separate locations within a period of 72 hours as part of the same act or transaction, or in 2 or more acts or transactions connected together or constituting parts of a common scheme or course of conduct, would be a severity level 9 person felony. The general penalty for theft of property or services of a value less than $1,500 is a Class A non-person misdemeanor. This bill also defines mail as a letter, postal card, package, or bag sent through the United States Postal Service or other delivery service, or any other article or thing contained therein, or a sealed article or thing addressed to a person. And I can take any questions.
Representative Hoheisel.
Thank you, Mr. Chair. Thank you, Natalie, for that breakdown. So just for clarification, this would apply to the package thefts we see typically during the holiday season from UPS or FedEx or anything like that as well?
Mr. Chairman, yes, the definition of mail includes anything sent through the United States Postal Service or another delivery service. So that's pretty open-ended there to include UPS, FedEx, any other type of delivery service like that. But it also includes any sealed article or thing addressed to a person.
Thank you, Mr. Chair.
Any other questions? Representative Heiberger.
Thank you, Mr. Chair. So as currently written, the 3 articles could be 3 articles of no monetary value whatsoever and still rise to a felony if there were 3 within 72 hours. Is that accurate?
I believe so, because I mean, it's just, I mean, it does have to be of a value of less than $1,500. So I suppose it would have to have some maybe monetary value. That's an interesting question, though, if the monetary value is literally $0. But yeah, I mean, it could be a very low monetary value. There's no floor. There's just a, so that's interesting.
Any other interesting questions for Natalie? Okay. We will move on to proponents. Eric Stafford.
Thank you, Mr. Chairman and members of the committee. Good afternoon. My name is Eric Stafford with the Kansas Chamber of Commerce, Vice President of Government Affairs, here to speak in support of House Bill 2229. I was going to make a great funny joke about opposing anything that Joe Molina wants, even though we don't have a position on the last bill, but he left, so it's not going to be as funny. So we'll move on and focus on the bill before us now. So this, underneath the Kansas Chamber's umbrella, we are the state's affiliate for the National Association of Manufacturers. So we have the Kansas Manufacturers Association, or Kansas Manufacturing Council, but we also have the Kansas Retail Council, so which is an affiliation of the National Retail Federation. This was an issue brought forward to us from our retail members, and when this was brought by us, I would say it was brought by a larger retailer. We do have some smaller independent retailers throughout the state. Got feedback from them as well. Some of those do have online presence, and they shared the exact same views that mail theft, package theft is a growing trend that they're seeing, and noticing that, when something's stolen, they're needing to do what they can to replace the product for their customer. So 2229 was brought forward. I think there was input provided from the law enforcement community to deal with the penalties to Representative Heiberger's question. If something's valued at zero, yeah, potentially, but I think it was also drafted in a sense to mirror existing Kansas law dealing with property theft. If somebody steals something of less than zero or less than $1,500 today that is arguably valued at zero, they're facing a Class A non-person misdemeanor, except as provided in Subsection B5 and B6. So I think with that input, if there's language to clarify that, I think we're open to that, but I think ultimately this was drafted to mirror what is currently in place for property theft under Kansas law today. So USPS mail, they oversee that. This is for other types of mail delivery services that's defined on page 2 of the bill, lines 17 through 20. So pretty straightforward. Would appreciate your support of the committee, and I am happy to answer any questions that you might have.
Thank you. Representative Carmichael.
Thank you, Mr. Chairman. 2 areas of inquiry, Mr. Stafford. Based upon Representative Heiberger's insightful question, it would appear that were this bill to become law, if an out-of-state mail order house who doesn't pay any Kansas taxes, use tax, sales tax, property tax, doesn't do anything to pay for the community, if they send out 3 pairs of socks to 3 different houses and they're stolen by the same person, then we have 3 thefts of quote unquote mail with a value of less than $1,500. And that's a felony. We protect those merchants with the full penalty of a felony. But if it's the ma and pa merchant down the street and somebody steals 3 pairs of socks from them, either at the same time or in sequence or days apart, doesn't matter, that's all misdemeanor theft. So the way I read this, it protects the out-of-state freeloading mail order merchant with a felony conviction, but ma and pa on Main Street, they don't get those protections. Am I misunderstanding the bill?
Well, I think that the Representative, good question, Mr. Chairman. I think that the delivery carrier would be employed within the state of Kansas, so they'd be paying income taxes. So I don't think they're fully a freeloader. But the page 2 of the bill deals with property of at least $50, but less than $1,500 is a severity level 9 non-person felony if committed by a person who has within 5 years immediately preceding commission of the crime, excluded any period of imprisonment, been convicted of theft or 2 or more times. So again, that is existing law that we are simply trying to mirror. If we need to put a $50 minimum threshold in there, we're more than happy to, but our intention here is to not give a company out of state that is viewed by some as freeloaders let them have less penalties, but to let them allow to have these same penalties that are in place under Kansas law today.
Well, with respect, Mr. Stafford, I don't really understand your answer, but time is limited. Let me move to a different topic. And that is, you use in your bill the phrase mail. And mail typically has a special meaning. It's typically thought of as United States mail, and it's a federal crime to steal United States mail. So why are we defining a package that I address specifically to Ms. Scott and leave in her office as being mail? Can't we find a word that doesn't have the connotation of commission of a federal crime of the weight of theft of United States mail, like happened in Speaker Pelosi's office a few weeks ago?
Well, I think the definition of mail in this bill includes the United States Postal Service. I mean, if we need a separate definition with a defining term, I think we're open to that. Whether you want to call it an Amazon package or a Best Buy package or a mom and pop Best Buy package, whatever you want to call it, I think we're open to that. But I think we're trying to encompass the fact that these delivery services, as technology has changed, that there are new services being provided, and they're shipped oftentimes and placed in our mailbox, which I think people understand what that means, even though it might not be exclusive to the USPS anymore. I think we're open to modifications to definitions that the committee seems fit, but I think that what we have on page 2 would be pretty sufficient because it includes or other delivery service, as there are new delivery services made available today through the economy.
Well, again, Mr. Stafford, you and I aren't communicating today, because I guess my point is that theft of United States mail is something different than stealing a package I leave on somebody's front porch or that UPS does. And by the way, if your clients are leaving Amazon or whomever your clients might be, are leaving packages inside United States mailboxes, that's a federal crime as well. Mailboxes are only for United States mail. So I hope you'll caution them if that's what they're doing. Thank you, Mr. Chair.
Mr. Chairman, I think our members utilize multiple delivery services to deliver their packages. Sometimes they might be through the USPS, other times they might be through FedEx or UPS. So,
but with respect, Mr. Stafford, my point is your clients can't go around putting things in mailboxes that aren't mail. That's against the law. Thank you.
You're probably aware of that.
Representative Wheeler.
Thank you, Mr. Chair. Can you hear me?
I can see you too.
You can see me as well?
Yes, very good.
Okay. In response, if I may, to Representative Carmichael, I did a little research on this today. Although my research capabilities without Westlaw and the other things are really not all that great. But from what I found, theft from a person's mailbox, where the mailman puts the mail in a box or a slot, is not federal mail fraud under the federal code, which is why I was kind of happy to see mail included in here, that if it's placed in the mailbox, it would be covered by this.
Well, I'll tell you, let me suggest we have Kansas Legislative research that aspect of the law for us, because I think stealing mail out of a mailbox is a federal crime. I've even represented people in law school charged with that. But if I could ask Mr. Chairman, do that research for us to find out for sure. Thank you.
We will have them look into it. You can finish your question, Representative Wheeler.
Actually, I was just raising an issue with Mr. Carmichael. What I understood, based upon my limited research, and I like the idea of going to legislative research, Representative, is from the mailbox, personal is no, cluster boxes, the boxes sitting on the corner, those types of things out of a postal truck are all covered under federal law. But let's have legislative research answer that question. And thank you. I have nothing further. Thank you, Mr. Stafford.
Thank you.
Any other questions? Do not see any. Thank you.
Thank you.
Next online, we have Ed Klump and committee. If you didn't refresh your email box, his testimony came in a little late to your email box. So it's there now. Ed, you're up.
Thank you, Mr. Chairman, committee members. I'm Ed Klump. I'm here representing the Kansas Sheriff's Association, Kansas Association Chiefs Police, and Kansas Peace Officers Association. We are here in support of House Bill 2229. Some of the proponents came to us with this bill and talked to us about it early on. I did some checking with some of our agencies, and it's too early to get 2020 annual data yet, but anecdotally, several of the agencies told me that they were seeing quite an uptick in these type of thefts of packages off of front porches, commonly referred to as acts of the porch pirates. I've listed in our testimony several things that I think raises a little bit of a concern with these types of thefts, regardless of the dollar value. There's been some articles recently about how much the people are using mail service now for medications and medical supplies and other essentials, partly because of COVID. So it's got an uptick in some things that may not be considered high dollar value, but certainly could have a big impact on people's lives if the receipt of those is delayed. I want to point out, if you look on page 1 of the bill, on lines 32 through 36, this is the exact same language that is in the proposed addition to the statute, as far as the dollar value and the application, how it applies. This is a provision that was put into place several years ago, probably more than I'd like to think of, to address a problem we had with what Representative Carmichael was talking about with the serial shoplifters. And those were hurting our local merchants, and they would go from one store to another, sometimes in a matter of hours, sometimes in a matter of just a few days, committing what were misdemeanor thefts, and everything was a misdemeanor. It never accelerated beyond that. And so the legislature, in its wisdom, passed this provision to add what is subsection B5 to address that problem. And I can tell you it had the desired effect. We had a pretty good size reduction in our cases of those serial shoplifting events that were going on. So, Mr. Chairman, I think that really kind of sums up what we have to say about this. We think there's a need for this. We think this approach is similar to what's been working with the serial shoplifters, and that's what we're really talking about here is the serial porch thieves. We would recommend the committee to pass it favorably, and I'll stand for questions.
Committee. Do not see any. Thank you, Ed.
Welcome. Thank you.
I don't show anyone else as a proponent. Is there anyone else online or here in person as a proponent? What about a neutral conferee? Anyone as an opponent? Seeing none of those, we will close the hearing on House Bill 2229. Committee, that is it for today. Oh, yeah, so general orders just came out. We do have a couple bills from Judiciary up, so if you've been asked to carry a bill, you might double check to make sure it's not you who is carrying it. And then also, tomorrow, we only have one bill hearing, if my memory is correct. It is this, for those that have been on this committee or have been on transportation, this bill's been, or a similar bill has floated through the process a couple times, dealing with school bus cameras. Last year, we did not have a vendor here to help us understand how it would actually work. So I believe tomorrow we're going to have a vendor that will do a presentation. So we'll hear that. If anybody wants to go back and look, last year it was House Bill 2532, so you could review the testimony and see what took place last year. That's the only thing we have tomorrow, because I want to have plenty of time for us to talk through the mechanics of how it would work and whether it's something we want to consider moving forward or not. So that's it. We will see you all tomorrow. We're adjourned. Thank you.